Okay, thank you for coming today. Welcome to How to Protect Your Stuff in 3 Easy Steps with the Mattar Firm. I'm Claudia DeJesus. I am the partner here at our Bonita Springs office. And thank you for attending. I'd like to learn a little bit about everyone here. So who's joining us from Fort Myers? Okay, great. Anyone from Naples? Wonderful. And from Bonita? Okay, Estero. Okay, right in between. Great. And so how did the majority of you hear about us?
TV.
Looks like it's working. Sounds good. So we're going to go over everything that we're going to do today. I'm going to make you a couple promises. I will ask for some promises in return. I'm going to tell you about myself as well. First, I want to review what you have in your handouts. Everyone has a folder. And in that folder, you're going to find several materials. First, you have an evaluation. That's the green sheet. It's the evaluation. You can feel free to begin to fill out the top of that. It's going to ask your name, phone number, how you heard about us. If a friend sent you our way, put their name down so we can thank them. And next, you're going to have some more paperwork. We're going to have a note sheet so that you can write down any notes that you want to take. We have a lot of you have our processes. That is that 4-step sheet, the blue one. That's going to walk you through the processes of estate planning. We believe estate planning there's a system to it, right? There's a process. And the first step in that process is coming to the workshop. So congratulations, you all accomplished that today. And the workshop is really important because estate planning is dense. It's a lot of information, and so we need to educate ourselves so that we can know what it is, who our creditors are, who our predators are, what the law is, and so that's the first step, is educating ourselves. The next step is the vision meeting. All of you today are going to receive a complimentary vision meeting for attending our workshop, and that is essentially a consultation. We're going to sit down, we're going to take an audit of what it is that you have, go over any estate planning documents that you have, and show you how to get to where you want to be. So we'll go through, we'll let you know what you've got going on, and fill in the gaps for what you need in order to achieve your goals. After that is our design meeting. That's when you come in and we sit down and we design your estate plan. And we'll go through all of the considerations with you and your loved ones. And the signing meeting is when we sign your documents. They become official, and you're handed a nice leather binder, and you've got everything ready to go. Something that sets our law firm apart from most is that we're going to go ahead and do the funding for you. So part of having a trust or having any type of estate plan is making sure that your assets are properly placed into whatever vessel it is that you've chosen to have. So we're going to go ahead, we're going to fund that for you. You're going to leave our office with asset protection if that is one of your goals. You also have some information in there about our firm. You will see a flyer with my photo and our founding partner William Mattar's photo on there. And that's going to give you a bit of information about our firm values and why we do what we do. Our firm's philosophy is that we like to help people, right? Helping people, it's what we do. So that gives you a little bit of information about that. We are also a national firm. We have offices in New York, in Buffalo, Rochester, and Syracuse. And we also service 16 states, so 17 including Florida. So that's really great for my snowbirds or for people who have perhaps a residence in another state. We want to make sure that you've got estate planning documents, whether it be in Massachusetts or in Florida, that you're ready to go. So, how many people here do we have that are married? Okay, how many years married?
25.
25, congratulations. And I know Raymond and Rose together for 34. That's wonderful. And how many single people in the room? Okay, great. So I'm going to be talking about the law as it pertains to married individuals and single individuals, and I will let you know the difference of each, okay? We've gathered information on what most people want to know. Most people want to know, how can I protect my stuff from the government, long-term care, and sometimes family, or how do I protect my family? What is a trust? What is the difference between a revocable and an irrevocable trust? How can I avoid probate, and do I need to? Is this something I even need to think about? And the answer 99% of the time is yes. Can and should I give my stuff to the kids or others? If I give my stuff away, will it take 60 months for it to be safe? So that's that 5-year rule that I'm sure many of you have heard of. We're going to debunk that myth. What is a power of attorney, a living will, and a healthcare proxy? What is the difference, and which do I need? How can I plan for my disabled beneficiaries? Are my IRAs safe, and do I need special planning for them? How can I avoid estate taxes? Is there anything else anyone needs to know? Came in here wondering. This pretty much covers it, right? So we're going to be discussing a lot today.
About property in multiple states.
We'll talk about that. We can talk about that. So the goals of our workshop are for you to be able to identify if your current plan meets your goals. You're going to hear a lot of things today, and you're going to think, maybe I have that, maybe I don't. We want you to understand what it takes to protect you and your stuff. Don't worry about learning all of the law. I'm going to tell the law in stories, so you can anchor back to certain stories. And at the vision meeting, we can clarify, we can go over again a lot of the information. And we're going to show you how to get what's missing. So we're going to make sure that you're all set. If you like it and you don't have it, we'll show you how to get there. If you don't like it, estate planning is not one fits all. So it's very personalized. So what works for your neighbor might not work for you, and vice versa. So we're going to be able to clarify all of that. There's 3 steps in planning and protecting your estate. We have to know the rules, which is why we're here today. We have to know our creditors, and we have to know our options. So that's how we break it down into those 3 steps. Knowing the rules. So when I talk about estate planning, I like to describe it as a ladder. We've got several different options, and at the first base, the first step of the ladder, we've got the government's rules. So we can choose to do nothing, and that's fine, but we have to be comfortable knowing that the government has set rules for us. So do we want Florida deciding what happens to our stuff and what happens to us? Probably not. And remember, we want to have a plan for when we're alive and well, alive and incapacitated, and after we pass away. So we want to make sure we account for all of those steps. So the government is going to have rules for us during our lifetime. If we don't go ahead and do an estate plan and take that control back, we're going to default to the government's rules. So what is a power of attorney? A power of attorney is a legal document that's going to allow someone to act for you financially. This is a document that grants a lot of power and at the same time doesn't grant enough in certain situations. So, right, as always, it depends. So, for example, if I give you a blank check, what can you take from me? Everything in my bank account, right? If I give you a power of attorney, what can you take from me? Literally everything. You can sell my house, you can liquidate my IRA, you can do anything. So it's a document that's very powerful, and we want to make sure that we tailor it specifically to our agent. We don't have to grant someone ultimate powers. We can give them a specific power. We can limit that power. Likewise, we also want to make sure that we have, welcome, no, go ahead and take a seat. Thank you. We just started, don't worry. Likewise, we also want to make sure that our agent has the necessary power. So, how many of you here did you know that you might have a power of attorney, but if you're incapacitated, that power of attorney cannot do estate planning for you?
While you're incapacitated.
Right. That's one of the main things that you would need, right? Is for your agent to be able to wrap up and, you know, make sure everything is ready to go in terms of your will, any living will. So we want to make sure that we're granting our agents expanded powers we want them to have, while being cognizant of perhaps limiting if we want to. So it's a big document, and you definitely need it, and we need some guidance for it. So what happens if we don't have a power of attorney? If we become incapacitated, the state's gonna have a guardianship hearing. What does that involve? Time, courts, basically the court system, a judge is going to decide who can make those financial legal decisions for you. And frankly, if we're incapacitated and we're in a moment of a financial or medical crisis, we don't have time to go through the court system, right? Because what is a crisis to you is not going to be a crisis to them. Next, we have our healthcare proxy and living will. So our healthcare proxy is the legal document that grants your agent the power to make healthcare decisions for you. And this again is a very powerful document that we want to make sure we have. We tell our clients we want to make this as specific as possible. Think of what we're doing to our agent. We are putting on their shoulders the burden of deciding whether we live or die, right? They have to make that decision, and then they have to live with that. So we say, let's put specific instructions in there. Perhaps you believe in life support, and that's great. Perhaps you don't. You can set limits to it as well. I want to be on life support for X amount of weeks, and then, you know, have the life support be terminated. Whatever your desires are, you can put that into that document so that your agent is executing your wishes and you're not just granting them a blank power, right? It's a really big responsibility. We always joke around and we say, name the kid you like the least, because it's a huge burden, right? So, we need that document. Again, who's gonna make that decision for us if we don't have that document? Two doctors are gonna have to come to a consensus, a joint decision, and there's gonna be some kind of hearing or trial before any decisions are made. So, we don't have time for that. We need these preliminary documents. The government is also going to have rules for us for after we pass away. So if we pass away and we don't have any type of estate plan, we're going to pass away through intestate succession. And that means that the state of Florida has decided which one of your kins gets what and at what percentage. And this can become really complicated for my blended families. And most of us have blended families. We've got either second marriages or children from different parents. So how do we make sure that who we want to receive our assets, that our beneficiaries are getting it in the way that we desire? We need to have a will. So your last will and testament, what is that gonna do? That's that binding legal document that's gonna say who's in control, who gets my stuff, but it requires probate. So in your will, you'll have your executor, and that's gonna be the person who's gonna go ahead and divvy up your things. Who gets your stuff? That's your beneficiary. And then probate, what is probate? Has anyone gone through the probate process?
It's a process where the courts distribute assets in your estate.
Exactly. And so, did you have personal experience with probate?
I was an administrator.
Okay. So you know how costly and how much time probate can take. Is that fair to say?
Takes about a year.
Yeah. So
if it's done properly.
Right. If it's done properly. We have it averaged at 7 to 9 months. Again, it takes about a year, and I've seen probate take 2 to 3 years. And it can be very costly. So if we only have a will, we have to be comfortable knowing that whoever our beneficiaries are going to have to go through this court process. It's going to cost them about 5% of our estate. In the state of Florida, that is not capped. So in the state of Florida, an attorney can charge whatever they deem reasonable. Where our offices are in New York, they cap it. You cannot charge more than 5% for someone's probating an estate. Here, it's whatever's reasonable. We've seen people being taken advantage of. You're already in a vulnerable situation if you're going ahead and probating a loved one's will. And so we want to make sure that if we can take that burden off of our family and we can streamline the process, that we do so.
Question for you.
Go ahead.
Is that 3 or 5%, Is that of the gross estate or the probate estate?
It's of the probate estate, but it does not take into account any debts. So for example,
I'm
if,
familiar with, you
yeah,
had a house and you have,
if you have
is
equity
that
in
the
a
higher
home,
amount? Yep.
they're not gonna probate it at 5% of the equity, they're gonna probate it at 5% of the value of the home. So, that's why I said 99% of the time we always wanna avoid probate. I really have not encountered a situation where someone says, yes, I want my loved one to go through that. We wanna resolve that for our loved ones. Right, because we won't be here, we'll be gone, but it's the people who we love and leave behind that are gonna have to deal with that. So what makes, these documents, what distinguishes them versus planning, right? We've got the legal Zooms of the world. That's not gonna get you a proper power of attorney. You might be giving too much power, allowing someone to sell your home from you, but then they can't make an estate plan for you if you're incapacitated. So whoever it is that you ultimately go to, we hope it's the Mattar Firm, but you want to make sure that your attorney is willing to personalize your estate plan, that power of attorney, that healthcare proxy. We don't want to give someone a blank check, and we want to make sure that we're guiding our loved ones through that medical crisis. We have here organ donation. So part of what we coach and talk to our clients about is, do you want to be an organ donor? And if you are, would you like to have the option to give it to your family and immediate family first before the general list? So those are things that you can do that most people don't know. Personal care plan. We sit down with all of our clients and we go through and we're going to create a plan for you so that when that day comes where you can't care for yourself, it's already been outlined what it is that your preferences are in terms of dietary restrictions or preferences, how many times a day you like to go outside, what it is that you enjoy doing on your free time. A lot of facilities in this area, if we're talking assisted living or skilled nursing home, actually require this document because it really helps their caretakers be able to provide such better service. Yes?
I have a question, however, I'm a bit slow. Is back to the power of attorney?
Absolutely.
Full authority with instruction. Can you have at least 2 opinions here?
Sure. That's a great,
Assign 2 people.
that is a great, thank you for mentioning that, because that's right. You can assign 2 people to have to serve concurrently, so they have to serve together. We would talk to you about the fact that, you might want to assign for 1. You can assign 2 people, but you never want there to be a holdup if you need something where you're waiting on the other individual's signature.
And then what if one of those 2
Passes away.
In the
Exactly.
meantime,
That's what I was getting to
easier.
next. Yeah. So it's really important that you have documents that have backups, right? I've seen so many people come into my office where their agent is now incapacitated or has passed away. So we want to make sure that your power of attorney has your agent, your backup agent, and a backup for your backup. Because we want these documents to serve you for several years. You don't want to redo this every time something happens to your agent. Likewise with your healthcare proxy. Next, we need to know our predators. So many people believe that their biggest predator is the government. We've got long-term care costs, our family can sometimes be our predators, and lawsuits, right? So out of these, clients typically think that it's the government, but the biggest threat to your estate, I'm here to tell you, is the cost of long-term care. Is your family?
Yeah, here.
It's the cost of long-term care, and I'll explain why. So how is the government predatory? Well, if we're staying at that base step of estate planning where we're just gonna default to the government's rules, we have to be okay with guardianship. If we're going up a level and we have a will, we have to be okay with probate. And then the government's always predatory in the sense that they charge us taxes, right? Why is long-term care the biggest threat to your estate?
Because of the cost.
The cost, exactly. Long-term care is currently averaging in Florida $9,171 a month. So that changes. Medicaid sets out new numbers. This is the government saying what the average is. Sure, there's facilities that cost less and there's facilities that cost more, but the number that the state of Florida puts out is $9,171. It's going up. In December, it was $8,998. So, sure, it was only about a $200 increase, but that's a lot of money monthly. So we've got to average that long-term care is going to cost us about $120,000 a year, and that's a significant hit to your estate, regardless of if you could have $3 million, and that's still going to be a big hit. There's different types of long-term care. We have stay-at-home care, assisted living, and nursing home. Stay-at-home can be less expensive or more expensive depending on how many hours a day you need care. Assisted living, again, can be middle of the road, and skilled nursing home tends to be the most expensive. So we need to start thinking about how are we going to pay for this care. It's not something many people want to think about, but we all need to think about that. So have we all heard of Medicaid, right? How many of you have lived the scenario where you have a loved one that's in some type of skilled nursing or assisted living rehab, and they're paying $10,000 a month, and their neighbor qualified for Medicaid, and they're receiving the same services, they're at the same facility. So most people want to know, how can I qualify for Medicaid without losing everything that I have? And we actually have answers for that. So how many of you have heard that Medicaid can take your home? How many of you have heard that you have to give all of your assets away in order to protect them? And if you give your assets away, you're going to have to wait 60 months, 5 years for those assets to be safe. Right? So these are all myths. These are not true. This is what we call our coffee shop rules. So you're at the coffee house with your girlfriend, and she's telling you about what happened to her loved one, and so this is the rumors that spread, right, and a misunderstanding. These are all false. Medicaid is a complex set of rules. There's exceptions and exemptions, and exceptions to the exemptions. So we're going to show you all of your options, but I want you to keep in mind that it's really important that you sit down and speak to a Medicaid professional that is not from the Medicaid office, because, no. But Medicaid is not going to say to you, hey, you put down an exempt asset. You're allowed to keep your home, or we don't want you to liquidate that IRA. They're never going to say that to you. So you need to educate yourselves and know what is safe and be able to sit down and understand what you don't have to lose to Medicaid in a nursing home. We also have other predators, right? We've got our family. We want to protect our family from predators. Sometimes we want to protect ourselves from our family being predators. I work with a lot of people who have early dementia, and so a lot of times they come to me and they are anticipating the possible vulnerability and specific family members who they think may try to take advantage of them in the future. And so we can plan for that and make sure that you don't fall susceptible, your loved one doesn't fall susceptible to that type of abuse. We have our blended families, which I spoke about. Remarriage, making sure, hey, how can I protect my spouse, but take care of my children from my first marriage, or vice versa. We want to make sure that we're protecting our children sometimes from themselves. How do we leave assets to our children without them spending it, squandering it away? Sometimes we have beneficiaries or children who have addiction issues. That doesn't mean we have to disinherit them. Let's go ahead and set limits on what they do with their funds and their money. Disabled beneficiaries. Everyone thinks that, if they don't currently have a disabled beneficiary, that they don't have to plan for that scenario. But we're here to help you plan. So we're going to account for the possibility that one of your beneficiaries may later become disabled. And how can we protect any assets for them? Divorce. This is a big one. All of my clients, whether it's their children or nieces or nephews or whoever they're leaving their assets to, I ask them, okay, is that individual married? Yes or no, whatever the answer is. Okay, if they were married or if they are married, do you want to protect them from divorce? What does that mean? If you leave them a certain sum of money or assets, do you want to make sure that if they're getting divorced, that's not part of their divorce settlement? And every single time I hear yes, right? You want to make sure that what you leave your family stays within your bloodline and isn't subject to a 50-50 split of any type of settlement later down the road. We also want to make sure we can leave some assets for any of our beneficiaries and it doesn't disqualify them for financial aid or any college aid. And then this is a big one, protecting ourselves from lawsuits. Right? We want to make sure that we're protected if we're driving home after this workshop and we rear end someone and that individual decides to sue us. How do we make sure our assets are protected? How do we make sure anything we leave our beneficiaries are protected? So we can do all of that. We know our predators, now we have to know our options. Estate planning has three core elements. Again, who's in control? You hear the word control a lot because it's the number one thing that people don't want to lose. They always want to be in control. So you are all going to be the ones who are in control. Who gets to benefit and when? Again, we're going to have a plan for you when you're alive and well, when you're alive and incapacitated, for when you're gone, and likewise for your spouse and your children, or any type of beneficiary that we're talking about. What are the typical goals of an estate plan? The one goal that I always see when my clients are doing an estate plan is that they want to stay in control. They don't want to become a burden to their loved ones and they want to keep it simple. So our goals for you are for you to know the difference between documents and planning. You're going to have a plan. You're not just going to have a document that allows someone to go to the bank for you. You're going to understand what that means for your whole plan. Understand all of the costs and how to minimize them. Your estate plan today is going to cost you significantly less when you pre-plan it than it would for your family going through probate. So I want you to think of that 5% number and know that attorneys can charge more than that, right, in this area. So at a minimum, that 5%, and going ahead and pre-planning is going to save us so much more time and money. So we want you to know all of your options and choose the right plan for you. We don't ever present one plan to our clients. We say, hey, here are your three different options. This is what A will get you, B and C, so that you can make your informed decision. So we've got a couple different options, right? We can do nothing, and that's fine. We stay at that base step of estate planning, but we've got to be comfortable knowing that we're going to take and use the government's rules. So we have to be comfortable with guardianship. We've got to be comfortable with intestate succession, and that's where that estate administration falls, right? The courts are going to decide what happens to our things and what happens to us. And the second option is, let me take that control back. Let me go ahead and do some estate planning. So now we're going to get into our stories, and I'm going to start teaching you Medicaid. And so we want to make sure that we're protecting ourselves from that biggest predator. I know that I can protect all of you tomorrow, right? Today, I can protect you tomorrow from your general predators. Lawsuits, your family, that's easy. But who's that predator with that extra long arm, extra power? That's going to be Medicaid. So when we're talking about long-term care, we want to plan for that. And we want to know, how do we minimize our costs so that we're able to afford the care that we desire? Again, we've got different levels of long-term care. We have stay-at-home care, assisted living, and skilled nursing home. And we've got a couple different options. We can private pay, so we can go ahead and pay that, let's call it $10,000 a month. $9,171. We can private pay. How many of you here have long-term care insurance? Okay, great. So long-term care insurance is fantastic, but again, it's a piece of your estate planning puzzle. Long-term care insurance is not going to cover, likely, each policy is different. So if you have long-term care insurance, I encourage you to read your policy. But typically, it only covers a portion of your care. So you've got to make up the difference and know how you're going to do that. When we talk about Medicaid, there's several different options. So we've got community Medicaid, which is actually a program where Medicaid will pay for someone to come to your house and care for you. And in some instances, your family member can even be your community Medicaid caretaker. So let's say you have a niece and they're caring for you. That individual can go on the county payroll, and Medicaid will pay them to care for you. Because they're cognizant of the fact that that's going to be better than bringing in a foreign caretaker. If you're a veteran, you're allowed to have a bit more buffer on that, on the allowance of what you're going to be allowed to have, and that goes for spouses of veterans as well. And then we've got Medicaid to pay for the full skilled nursing home, long-term care. So whenever we have clients that come to us, we're going to separate them into two categories. Whether they're thinking of protecting themselves from the ultimate creditor or not, we're thinking of it for you. So we've got our crisis clients and we have our pre-planners. And I'm going to talk about the difference between each. First, I'll tell you about my crisis client, right? I'm going to use an example. Names have been changed. So if a crisis occurred, would you qualify for Medicaid? I'll tell you about Mary Smith. She was the eldest daughter, is the eldest daughter. And Mary came to one of our workshops, and later on, she called our office, and she said, you know, my mom has just had a medical crisis, and my dad is scared that he's going to lose all of his assets. I said, okay, Mary, tell me about what happened. So her mom was perfectly healthy, slips and falls, breaks her hip. What happens? She goes to the hospital, has to have surgery, and is transported to rehab. So Mary and her family were never thinking of mom needing any type of nursing home. It wasn't on their radar. But they had this emergent situation, surgery, and then rehab. And so during that time, who's paying? Medicare, right? And most of us think, I'm going to be safe. I have Medicare to pay for that. Well, Medicare is going to pay for your situation as long as it remains emergent. So they'll pay for that hospital, they'll pay for the surgery, and they're going to pay for a little bit of rehab. They're supposed to pay anywhere from 60 to 90 days, but we tell people you should not count on Medicare paying for more than 20 days of rehab. By that 20th day, you're going to be receiving a notice in the mail. Some of you may have lived it with a loved one, or I've had clients themselves that have lived that. And you're going to be receiving a notice in the mail that says, if your condition isn't progressing at the pace that Medicare thinks it should, they stop paying. And so now what happens? We either need to private pay, so we need to come up with that $9,171 a month, or whatever it may be, or we need to qualify for Medicaid. Well, what's the problem with private paying? We typically have people who are depending on us outside of that nursing home, right? In Mary's case, her mom was in rehab, but dad is still very much healthy, living his life outside of the home, has his bills to pay. So they were really fearing, where are they going to come up with these funds, and are they going to have to liquidate everything that they have? So Mary let us know that she was calling us as a second opinion. And we went through her scenario, and I said, all right, well, let me know what the first lawyer told you. And she said, well, mom and dad have a house, and the lawyer said it was safe. I said, you're right, Mary. You're allowed to have Medicaid, and your house is safe. And so for my single individuals in the room, we're lucky we live in Florida, and we are allowed to have our homes. If we were were in New York, the rhetoric would be different. If you're single in New York, you're not allowed to have your home. Only married individuals are allowed to have a home and qualify for Medicaid. So, if you're ever thinking of relocating, you call me first, I run the analysis for you. Florida's actually a pretty generous state for us to age in. So whether we're single or married, Medicaid lets us have a house. What about the car, Mary? What did the lawyer tell you about the car? She said the car is safe. I said that's right. What about the cash? She said the cash is safe. Okay, great. He was correct. And what about your stocks and investments? What did he tell your dad about that? And she said, well, he said we could pay the legal fees from that. I said, okay, that's right. And we would have to pay that for 5 years, and in 5 years, Mom would qualify for Medicaid. Well, here's the thing. If we are paying $9,000 a month, and we're multiplying that by 60, we're gonna need a lot more than $275, okay? So, and that wasn't right. So I said to Mary, I'm gonna send you our asset protection worksheet. Each of you have 2 of those within your packet. And that's a snapshot. It's gonna ask about your assets. So you send it back to us, we provide an analysis. So I sent Mary that asset protection worksheet. She filled it out for Mom and Dad. And what I returned to her was, I said, Mary, we can save the house, we can save the car, we can save your parents' cash, but guess what? We can also save their investments. And she was actually pretty frustrated. She said, you know, they don't have to lose the $275. I said, they don't have to lose the $275. It's safe, it's protected. We're gonna protect it for them. And she said, you know, what's the difference? I said, well, that's what we know that we can do within the bounds of the law, within the bounds of Medicaid and the law under the state of Florida. So the first lawyer was someone who was trying to help them out, had helped them with the closing of a home, and was doing this as a favor. And so that's wonderful that that person wanted to help them, but it goes to show how it's imperative that you meet with someone who is skilled in asset protection and Medicaid, because there are so many exemptions and exceptions. And you'll know if you're talking to someone who knows about Medicaid, because we get excited about how much you can save and how much you can actually, what you can do. So Mary Smith's parents, they had $650,000 qualified for Medicaid right away. We were able to save 100% of that. Our next scenario is, okay, we're not all in crisis mode, right? We're sitting here, we've got people who are healthy, you're gonna be my pre-planners. So very similar to Mr. and Mrs. Richards. They came to us when they were 75, and they weren't sure, they were knocking on wood. They said, you know, we hope to remain healthy. We are thinking of putting everything in our daughter's name. I said, hold on, before you go doing that, let's talk about it. First of all, we decided against that, not only because it seriously disadvantages their daughter, and you know, putting all of that in her name elevates her risk exposure, but it was completely unnecessary. So we went through their scenario. They had a home, $350,000. We knew it was safe. They had cash of $152,000, cars of $25,000, and stocks and investments of $250,000. So in total, the Richards had about $777,000. They thought they had to give that all to their daughter and hope she didn't run off, right? So what were we able to protect? We were able to immediately protect $649,000 of that. What was left at risk? 128. So we were able to say that of Richards, we're able to protect about 80 some odd % of your estate. 128 is going to be at risk, but it's not going to be at risk forever. After 37 months, that number will go down by $3,459 a month until it's all safe. So their immediate exposure went down greatly. That's what we can do with the exemptions and exceptions and the Medicaid law. But we all have our own numbers. So this is different for all of us. This number here is going to be different. The amount of money So they were pretty happy with that, and they made it to that point where everything was protected. We typically are able to protect anywhere from 75 to 100% of someone's estate. So typically that's where people fall into. With the Smiths, they were able to protect 100%. With the Richards, we protected about 86% until that got to 100. So we keep talking about protecting our stuff, avoiding probate. How do we do that? We need to do that with the right legal vessel, and that's a trust. A trust is going to have three parties. We have our trustee, and that's all of you. You would be your own trustees. So we have our trustee, that's who's in control. We have our grantor, again, all of you, you're the creator of your trust. And then we have our beneficiary, who is whoever we want to be receiving our assets. And so not every trust is going to protect us from Medicaid. That's a big misconception as well. People think, oh, I've got a trust. We've got to make sure it's the right trust. A testamentary trust, that's a trust that's created in a will. It does not come into existence until we pass away. So what does that mean? If we only have a will, we have probate. So a testamentary trust is not going to avoid probate for your family. A living trust is what you need in order to have that probate avoidance. A living trust is something that becomes active while you're alive. We've got different types of living trusts. We have revocable and irrevocable. I want you to think of a revocable trust as an open box, okay? And I want you to think of an irrevocable, which is your asset protection trust, that's your Medicaid protection trust, as a closed box. And so, which type of trust is right for you? Well, it depends on what your goals are. I also want you to think of trust as a little wagon, and I'll explain why. So people think, why is it that I need a trust? So I'll demonstrate. Imagine that I'm holding in my arms my house, my car, my IRA, my bank account. And I'm walking along the road, and I trip and fall. And me tripping and falling is either me becoming incapacitated or passing away. What's going to happen? My house goes over here, my car's there, my IRA's who knows where, and my family has to come in, pick everything up, make sense of it, send it through the probate process, and that's how they can gather my belongings. Now, if I have a trust, I have my red wagon, I go ahead, I put my house, my car, my IRA, all my things are going to be in my red wagon. And now I'm walking along and I trip and fall, and what happens? My stuff stays in the wagon, right? It hasn't gone anywhere. It remains within that protected vessel. And my family comes and they pick up where I left off. They can grab that handle and continue on forward. So a trust is not only a way to get protection, but also it streamlines the whole process for your beneficiaries. We also refer to trust as our rule book. We like to tell our clients, if you can dream it, we can likely implement it. Your trust is personalized, so you get to decide who's going to be your co-trustee with you, right? Who are your beneficiaries? Do you want to set rules to those beneficiaries? Do you want to set limitations for any kids or grandkids? One of the most interesting limitations I've had was a client who left money to her grandchildren, but it was matched, whatever was on their W-2, right? So that kept them motivated to continue working.
Oh.
Yeah, very interesting, right? And that was something, hey, she dreamt it, we were able to implement that for her.
So was that an incentive trust?
No, that was just a trust that she continued forward, but there were limitations. The children could only recover a match of what was on their W-2. So your trust allows you to create your rules. You're going to have to integrate your rules with your life. That's where we come into play, and we're going to help you do that, make sure that all of your assets are within your trust. But then you have to maintain your rules, right? Life changes. sometimes beneficiaries change because our relationships with our loved ones tend to change. Sometimes we have additions to the family. Sometimes we have subtractions. So we can account for all of that. We have to plan for that. So what sets our trusts apart from others? A lot of trusts are very simple, and they're going to require still 2 doctors to deem you incompetent. They're only going to get you probate avoidance if your assets are retitled to it. And they're going to just distribute your assets outright at death, which means that your family is not going to be afforded asset protection. So when you have what we call a pure grantor trust, that's your asset protection trust, we've got personalized disability rules and instructions, so you get to decide who your disability panel is. So whether it be a child, a spouse, whoever, a friend, you get to decide who your co-trustees are. You can always change your beneficiaries. And you're going to get that asset protection. You're going to be able to plan for your retirement, your IRAs. You're going to be able to plan for any spouses, and we'll talk about how. And your children and your beneficiaries. So when we go through all of this, you're thinking, okay, how does this all work? What are we doing here? So I need 2 volunteers. What about you, Rose and Raymond? Will you be my volunteers?
Sure.
Great. Okay. So Rose and Raymond, they've been together 34 years. So I'm going to give you these $2. Don't get hung up on the fact that they're just dollars. We're going to pretend they're $1 million each. Okay? Okay. So I've given you $2. So what can you do with it? You can save it, spend it,
Invest it?
invest it,
I would take trips.
take trips. But if you can save and spend it and invest it, then what can Medicaid do with it?
Take it.
They can take it, correct, right? What we work so hard for, they can take from us. So what are we going to do? How are we going to protect that? We're going to go ahead and move your dollar over, Rose. We're going to put it into a trust, right? And Raymond, likewise, move your dollar over. We're going to put that into a trust. And you can decide to make a plan together. You can decide to make a plan for each other separately. Doesn't matter. We're going to be able to protect your assets. So we go ahead. We have our dollars in a trust. And Raymond, I'm sorry. We're going to get rid of you, right? You passed on. You're going to be waiting for Rose. So who's your beneficiary? You've left your dollar to Rose. Now give your dollar to Rose, right? But it's protected because remember, he put it into a trust. And so Rose, tell me one of your children's names.
Denise,
Denise, okay, great. And another one.
Chrissy,
Chrissy, fantastic.
I have 4 of them.
I know. So Raymond, you've left Rose your $1 million, and you've said, Rose, I want you to manage this with Denise. You have ultimate powers, Rose, because you're the beneficiary. I'm going to leave this for you. You're going to get to control it. But Denise is going to be your co-trustee in case anything happens. She's going to be there to help you out. So Rose calls Denise one day and she says, you know what, Denise, I need $20,000 from Raymond's trust. I'm going to go buy a new car. And Denise says, Mom, what do you need a new car for? Your car's fine. Raymond didn't leave you that money to get a new car. No, you're not getting a new car. And so, you know, Rose is upset. She's talking to Chrissy, and Chrissy says, well, Mom, you deserve any type of car that you want. And so Rose remembers that Raymond gave her ultimate powers, and she can hire and fire her co-trustee at any point. So what does she say? She calls up Denise and she says, Denise, you're fired. Chrissy's now my co-trustee. And who gets their car? Rose does, right? So let's back it up and let's talk about, let's say now you have Raymond's dollar, right? His $1 million. And you've been having some trouble managing the pool since he's gone, so you've hired a pool boy, right? And
Tom Selleck.
yeah, Tom Selleck. Tom Selleck's the pool boy. And you call Denise and you say, you know what, Denise, I'm going to take $10,000 from the trust. Me and Tom Selleck, we're going to Aruba and we're going to have a nice time. And
I mean Hawaii.
Hawaii, okay, Hawaii. You're going to Hawaii.
Hawaii.
I'm surprised you said Hawaii. So nice. You're sending her off with Tom Selleck to Hawaii.
That's where the movie, the TV series was,
Oh
right?
yeah, that's right. So Denise says, Mom, Raymond did not leave you money to run off with Tom Selleck. And what does she know? And you say, well, Denise, remember what happened a couple months ago when you told me I couldn't get that car? I know Chrissy's going to approve me to go to Hawaii. And she says, well, here's the funny thing about Raymond, Mom. He said that once you remarry or enter into another co-partnership, you're no longer allowed to fire me. And you say to her, well, Tom and I are just friends, don't worry about that. But Raymond's gone ahead and defined remarriage and co-partnership as one night with Tom Selleck. So what has he done there? He's given you some funds, right? You've received his assets. He's given you the power to hire and fire Denise, but he doesn't ever want you gifting that money away to your new husband or friend, whatever it may be. So he set limits on that. So now let's say, Rose, you have your million and you've left it for your girls. And I'll just use Denise and Chrissy as an example. So they're going to split your million and Chrissy is going to get $250,000. And is Chrissy married?
Yes.
Okay. So now Chrissy gets her $250,000 and you've left her also a condo. Okay? And she moves into that condo with her husband, and that condo is not in her name. That condo is in the name of the trust, so for Chrissy's benefit. So Chrissy gets to control, and one day her husband comes home and he says, you know what, I think I'd like a divorce. I want you to sell this condo and give me half of the proceeds. Well, guess what? That condo is within a trust. That condo is not part of any divorce, settlement, or proceeding. Her husband cannot access the condo. Now, a lot of my clients want to make sure that their beneficiaries are able to have control, right? So now remember, Chrissy is her own trustee. So she can sell that condo, but where are the proceeds from the condo going to go? Into a protected trust account, rather into any type of checking account where they would be exposed. So that's a couple examples of that. Any questions
And then
on
if he has
trust?
children, let's say God forbid something bad happens to Chrissy, it would go to her children.
Exactly.
Her
So
therapies.
you get to decide,
Uh-huh.
right? You hold that decision. If something happens to Chrissy, do you want her proceeds to go to her children? Do you want those assets to go to her children? Do you want them split amongst her sisters? You get to choose.
Well, what I would do is, I have 4 daughters, so it's
Yeah.
equal. And then God forbid one of them passes, it would go to her children.
Right.
And then I would put a certain age on them being they're young.
Absolutely. See, now you're thinking. You're thinking of all those design considerations. What do I want to do? What limits do I want to set? And so now we have a scenario where Rose has her million and she's got Raymond's million and she has to go into some type of nursing home. Well, what happened? She fell, she wasn't planning on it, right? Now she's got to get rehab and Medicare has stopped paying, so she has to pay. So Medicaid does not see Raymond's money as your money, right? That was left in a trust, so they're not going to include that in your estate. And then we've got your million, right? We still have your million there, but what's happened? You've put it into an asset protection trust. Enough time has passed, right? That 37 months, we all have a different amount. But also, we've given you a co-trustee. So Medicaid comes knocking on your door and they say, well, you've got this $1 million in a trust. And you say, well, that's really nice, but my co-trustee Denise, good luck getting through her. You're not going to be able to access the funds. So that's why we always appoint a co-trustee. We want to give you that formality that's going to go ahead and give you some extra protection.
Excuse me, would I have to tell Denise about it, or can I keep it to myself?
So, that's a great question. Remember, as trustee, you are managing. So, Denise is going to have limited powers, right? If she's a trustee, yes, she has to know about it. But another one of your daughters could be whoever. But your trustee, they're not going to have the same powers as you. So while you can access your bank accounts within the trust freely, your co-trustee won't be able to. We talk about these limitations with you. Likewise, your beneficiaries, they can't grab into the trust and take out. Only you have the power to make a distribution, right? And you're still going to be able to access all of your income. And so just think of your trust as your protected box where you put your stuff in. Let's say you want to buy a boat. You can buy it with trust money, but you want to title it to your trust. Let's say you want to sell your house. You can sell your house, have the money go into your trust, buy a new home in the name of your trust, right? We want to keep it all protected. Yes.
I have a question. Actually, I
Yes.
have two questions. One is, if you're talking, let's just say for Medicaid,
Yes.
your income is too high to qualify for Medicaid. By moving into the trust, does it reduce the income that you have?
Yes, it does. So, that is a very specific scenario, and I'm going to touch on two things. The general answer is yes. We can move that income into the trust depending on what source it's from.
And you can still access it?
Well, if you don't want Medicaid to come after it, you don't want to be able to access it. But, do you have a daughter or son?
Mm-hmm.
Okay, what's their names?
Janine and Michelle.
Okay, so let's say you have my mom's name is Janine. I love that. So let's say you have your pension, right? And you're going to reroute that into your trust. If you want it to be protected, you have to forfeit right to it. But Janine can access it for you, right? You've given her that power. And Medicaid doesn't mind. So
that would reduce your income for
Yes.
Medicaid purposes, and how far in advance?
for
would it
Medicaid
have to be-
purposes.
Yeah, but how far in advance does that have to be planned out?
Well,
Before you enter, let's say, a nursing home?
and that goes into my second, the second scenario, which is
Okay.
another reason, let's be thankful we live in Florida. Not every state affords this. We're allowed to have what they call a Miller Trust. Now, if you have an asset protection trust and the income can be rerouted, you don't need a Miller Trust. But, in general, if you have too much income, Florida has said, okay, have this Miller Trust, which is what we call a qualified income trust, and let's say you make $3,000 a month, and Medicaid only allows you to have $2,000. Florida's going to allow you to get Medicaid. Why? Because if you have this Miller Trust or qualified income trust, they're interchangeable terms, you're going to take that extra $1,000 and you're going to put it into this qualified income trust account. It's an account that's open at the same bank where you bank. And what does that do? That says Medicaid is going to say, okay, now you qualify. And why do they allow it? Because you are the beneficiary of the money in that account while you live. But after you pass, it goes to Medicaid. So they allow that. They're going to allow you to put your extra income in there because they're going to reclaim it at the end of the day. And so for those that have Miller Trust or qualified income trust, and we can talk about that at the vision meeting, you want to be cognizant of the fact that you don't ever want to put more money in there. You want to just put in there what is extra. So that is another solution to having too much income, and that solution is really only available in Florida, Texas, a couple states. Not every state allows that.
And how far in advance do you have to plan it? Let's say in 6 months you're going to a nursing home. How far, is it the 3-year rule again, 37
So,
months?
no, it's not. And that 3-year, that was just, that 37 months was just an example. So that could be different for you. It could be 18 or 6. So trust, qualified income trust, and be able to qualify for Medicaid. That doesn't have to be done in advance. Your asset protection trust should always be done in advance, because remember, your asset protection trust, the beneficiaries are your loved ones. With the Miller Trust, the beneficiary is Medicaid. So that's why they allow you to do it last minute, because they're going to get their funds back one way or another. So now you have your rule book, you've got your asset protection trust. What do you have to do? We've got to integrate it, okay? I've seen a lot of people walk through my door and they have some type of trust, but they've never put anything in it. So we're going to help you with that. We're going to do it for you. Put your house into your trust. Put your stocks and bonds into your trust. Any banks and brokerage accounts, we walk you through that process. We talk about it. We coach you through it.
I'm sorry, can I ask one question?
Yeah.
I'm still a little confused if we have an asset protection plan. How long does that have to be in there before, you know?
Right. So it depends on your family's specific scenario. For the Smiths, they were able to get it and immediately qualify. They didn't have to wait any months. For the Richards, they had to wait a couple of months in terms of having it all be safe. But remember, once they put it into the trust, they immediately protected $650,000.
So what makes that determination?
It has to do with the Medicaid numbers that change twice a year. In
You got
January.
enough months until you qualify, until you bring that down.
Exactly. January and July, those numbers change. And we have to calculate if those assets are exempt. And then we have to calculate the allowable numbers. There's a division that occurs. So in the Smith situation, their assets fell within the parameters of Medicaid, the numbers, and were exempt once we properly planned for them. In the Richards, $650,000 of it was. The $128,000 that wasn't began being protected at that reduced amount. So for example, for your family, we would be able to provide you the number, the percentage, what would be at risk. With the asset protection worksheet, we're able to give you a worst case scenario saying, hey, if this happened tomorrow, this is what we can do. And that way you know, knock on wood, it's not going to happen tomorrow. Hopefully, we're going to have time, right, for it all to be safe. So once I create my rule book and I integrate it, am I all set? Well, it depends, right? Our family changes, our finances change, health, the law. So we have to maintain it. Our estate plan is a living thing that we have to think about and maintain. So we're here to do that for you. We have a maintenance program. And we go ahead and we call our clients several times a year. We do a review meeting. People acquire assets that they forget to put in their trust, and even at our review meetings, did you acquire any more assets? No, but then we talk about, oh, hey, you took this family vacation, and where'd you go? Oh, across the country, on what? Oh, we bought an RV. Well, let's plan for that, right? We didn't put your RV in your trust yet, so we go ahead and keep in touch with you. We also have events for our maintenance clients. That's always an option. People really like it.
What is that 1% capped at?
So, fees capped at 1%. For our maintenance clients, if there's ever any type of court proceeding that needs to take place, which there won't be if you have a trust, but let's say you've named Denise as trustee, and she's just not up for the job, and she wants us to go ahead and administer the trust, that's going to be capped. We will not charge more than 1%.
Is that of the probate estate or the gross estate?
Well, that would be of if
Well, there is
something
no
needs
probate
to be
estate.
probate, right?
So it's just the gross estate?
Correct. If we're administering a trust, it would only be of the trust estate. So that's a great benefit for our maintenance clients because they're able to give that to their family. And for those not interested in the maintenance program, there's self-maintenance, right? Where you kind of do a self-check of, hey, has anything changed? Do I need to, make any updates? So the goals of our workshop are for you to identify if your current plan meets your goals. I'm sure you all have a mental inventory right now of what you have. Understand what it takes to protect you and your stuff. If you're just looking for probate avoidance, we can do that through a revocable. But remember, if you want to be protected against nursing homes, you need an asset protection trust, that closed box trust. And show you how to get what's missing. So that's the easy part. Most people want to know, how can I protect my stuff? What is a trust? We learned the difference between each today. How can I avoid probate? We need a living trust. We don't avoid probate with just a will. It's just a piece of that puzzle.
So question, if, say 95% of your assets are either in a TOD or TOD, those assets would escape probate, correct?
They would, but you're not getting any type of asset protection for them.
Understood.
Yeah, but you are correct.
Okay.
So you have, if you have a, what is it?
Transfer on death or?
Oh, yeah, trust, not trust, is it trust?
Payable on death,
Yeah,
transfer on
payable
death.
on death. Okay.
Can and should I give my stuff to the kids or others? We say you love people too much to just give them things, right? Give it to them in a protected vessel. If I give my stuff away, will it take 60 months for it to be safe? Not likely. Remember, we all have our own numbers. And most of the time, it's less than 5 years. Always. And we're able to protect, like I said, at a minimum, typically about 70% of people's estates. What is a power of attorney, a living will, and a healthcare proxy? We went over, those are the documents while we're alive. At minimum, we need these. How can I plan for my disabled beneficiaries? We want to make sure we leave them assets within a trust so they're never disadvantaged from any government programs they may qualify for. Are my IRAs safe? It depends, right? We need to take a look at them, see how they're structured, see what point you're at with your IRA. Are you taking distributions? We can do that for you in terms of telling you if it's safe. And how can I avoid estate taxes?
Well, if the IRAs are, you put your beneficiaries, nobody can touch that, right? Because I have mine and my 4 daughters.
Right.
as
So,
beneficiaries.
yes, those are, so they are the beneficiaries, but, and again, in most states, if you needed a nursing home, you would have to liquidate your IRA. In Florida, our IRAs are safe as long as we have them in payout status. So we can take a look at that. That's again something that you would put down on the asset protection worksheet. It asks retirement funds, IRA, things of that nature.
Thank you.
Yeah. I always like to end with this quote. Rockefeller said, "Own nothing, control everything." What we have in our personal names is always at risk. We're at risk from creditors that might come after us, a typical lawsuit. And it's at risk, especially when it comes to long-term care. So who do we want to own it? Our trust. And who controls our trust? We do. So own nothing, control everything. That's what we can help you achieve. So did our time go by quickly? Yes, great. Did we learn a lot?
Yes.
Great. And did we have some fun?
And I made $2.
And you made $2. Look at that. That's true.
That's taxable
Thank
income.
you. So I ask you that you fill out the evaluations. At the bottom of your evaluations, you will see that it will ask if you would like a vision meeting. That's your complimentary consultation where we're going to dissect your personal plan, right? Because we all have our unique scenarios.
And when did that expire?
That's good. Amanda can make your appointment today. We're happy to meet with you whenever is best for you.
No, but I'm saying, is there a certain date where, no? Thank
Is
you.
that the same as 401, as long as it's payout modes in Florida protected as well?
Yes. So if you check yes at the bottom, we can give you a call later this week. You're welcome to make your appointment today. Amanda's happy to make that for you in the back. And at your vision meeting, what are we going to do? You all have asset protection worksheets. I would ask that if you want to make the most of your vision meeting, you fill those out. So I can hand you that analysis and we can go through your worst case scenario, right? Because I always feel that if we're prepared for the worst, then we're ready to go, right? If we know what's going to happen tomorrow, if something happens, we're good to go into the future.
With these forms, let us just say that you marry, have some separation of assets. You need 2 forms? Or
You
one?
don't, no. The forms are split up into a column for you, your spouse, and I wouldn't, you can put it all in the same form because So, yep,
I like a meeting for all three of us.
Absolutely.
To discuss their stuff. Do you only put
Yep.
yes on mine or just
yes,
one?
mark
for
yes on yours and put both of your names, and then Amanda can set the meeting. Thank you.